From finance too.
We also facilitate business planning by identifying and resolving mitigation requirements up front and help us do a better job of addressing cumulative effects from the development of well fields over multiple years. Fifth, we've improved the timeliness of our permitting process by increasing the efficiency of our environmental reviews and adding needed staff. Again, I want to highlight several things that I think are important about these rules. First, we consciously avoided a one-size-fits-all approach to these issues. Instead, we tried to tailor the rules to local conditions and differentiate it between different areas to the greatest extent we could. In addition, the rules provide operators with options and incorporate flexibility where they can. For example, there are certain procedural requirements or procedural inducements for operators to undertake landscape level planning, but it's not a requirement. They're not forced to undertake that planning. Similarly, operators can obtain variances from certain environmental requirements, but they have to obtain approval for the variance not only from our agency, but from the Department of Public Health and Environment, which ensures that, that measures are in place to attain the environmental objectives of the regulation in question. And finally, we've sought to minimize the disruption to the industry from the new rules and the changes in the new rules by phasing in substantive changes over time, by adding staff and providing training for new requirements, and by grandfathering existing permits and applications to ensure that the industry would have a portfolio of permits that it could continue to draw upon and use during the transitional year. Now let's talk for a minute about the results of these changes, because it's interesting. I don't want to give a wrong impression. This was a very hard-fought battle, and in fact, the oil and gas industry in Colorado is still suing to overturn some of these regulatory amendments. And there were predictions that, that these changes would drive the industry out of the state. This would be calamitous for our industry employees, for local governments which depend on these tax revenues that I mentioned, and that it would have a dramatic negative effect on the state's economy and its residents. But that's not at all what we've seen in the 18 months that the rules have been in effect. During that period, we've issued about 6,500 drilling permits. We reduced permit processing times by about 40% below what they were several years ago, prior to us amending the rules. And drilling activity is on the upswing in the state, notwithstanding the low gas prices that were noted previously. So far this year, we're among the national leaders in the United States in issuing drilling permits. I think we're probably second or third at this point in the country in the number of drilling permits we've issued this calendar year. And we're the regional leader in the Rocky Mountain West in new well starts, in initiation of new oil and gas wells. From an environmental standpoint, we've seen much greater use of closed loop and pitless drilling systems and improved stormwater management, all of which is helping to protect ground and surface water within the state. We've also seen the oil and gas industry voluntarily develop 12 wildlife mitigation plans covering 550 square miles of our most valuable wildlife habitat, which is home to some of our most iconic species, cutthroat trout, elk, bighorn sheep, sage grouse, bald eagles, and so forth, and will also allow for the drilling of hundreds of new wells in a manner that's protective of those species. And these are plans, again, that the industry has worked out with the State Division of Wildlife in a collaborative and cooperative manner. Thankfully, we've only had to request chemical inventory information on 2 occasions, where in one case an employee, in another case a neighbor alleged that they may have been exposed to chemicals at a well site. In both instances, our new regulation worked as intended. We got the information we needed to complete our investigations in a responsible responsible and timely manner. To me, these results demonstrate that energy development and environmental protection are not a zero-sum game. We can do both. We can provide needed energy, clean burning or cleaner burning natural gas, which is vital to our economy and our quality of life, while also better protecting our water, our air, and our wildlife and other environmental resources, which are equally or even more important. At the end of the day, we're all energy consumers and we're all environmentalists. Thank you.
I'm just going to start off with a couple of questions we've collected, but if you have others, we have our front of house staff collecting your questions, so please feel free. The first question is to Val, Washington. Val, what is the law or legislation in New York State that allows the moratorium for deep shale permits? And is there, to your knowledge, similar legislation in other jurisdictions in the United States?
There is no actual moratorium. It's a kind of a virtual moratorium, because our the way the environmental impact law works, the environmental quality review law works. If a well permit comes in that's not generic, does not come within the 1992, there has to be an impact statement. So there's nothing to prevent a driller to come in and do an environmental impact analysis in pursuit of a permit. They would not have a complete application until they have done that. The drilling companies have chosen to let the state do this. Again, it's a huge undertaking. So it's effectively a moratorium, but it's not an official moratorium. There were several bills in our legislature calling for a moratorium. One passed the Senate that called for a moratorium until next May, and the Assembly never acted on it. At this time, it's hard to tell when we'll actually be issuing permits for Marcellus Shale, but it didn't seem to me that the May moratorium was a very aggressive legislation in light of what's happening. But let me just say a word. There's some confusion about the New York City watershed, a so-called moratorium in the New York City watershed. We've already announced publicly that we will not be including the New York City watershed or the Syracuse watershed, which is Skaneateles Lake, in this particular supplement, because there are added issues that we didn't want to complicate or slow down the process. There's a very serious misunderstanding about what that means. We are not saying that we think the impacts to New York City watersheds, which is a system of reservoirs north of New York City in the Catskill Mountain region that supplies water to New York City. It's not because we're afraid that the industry is going to pollute that water and people in New York are going to get poisoned. New York City is under a filtration avoidance determination. They do not filter their water that goes into New York. It's very good water, drinking water. And it would cost billions and billions of dollars to filter it. It's a very delicate document. Nobody believes it's going to be in place forever. If there's any development in the watershed, it threatens the FAD. So it may be only a few more years before New York can benefit from this determination. Any kind of development, whether it's housing, whether it's new industry, whether it's Marcellus shale drilling, threatens it because of the threat of turbidity, which interferes with the ability to get bacteria and microbes out of the water. So it's really a very different issue from the other issues we're addressing in the EIS.
Thank you.